6 of the daily list. And this matter may be adjourned for the day, Your Honor.
On the prayer of Mr.
S.A. Borboya.
Yes, next.
Highly honored.
And of item number 1 in the hearing list, Lordship. May I pray, Lordship, only for
What
the
hearing list?
praying for adjournment only for the day, Lordship.
You are not taking up hearing list to do. We'll take up criminal matters.
May I please your lordship, I beg to mention for item number 1 of daily list. Only this matter may be taken after 2 weeks.
What is your name?
M. Bora, lordship.
On the prayer of Ms. Mbora matter stand resolved for a week. Next.
Yes, your lordship, I beg to mention, I did the matter come up for orders. WPC number 4820, foreigners tribunal.
Why order?
Well, it is old pending
Hmm.
2019.
It will be listed, it will come up for hearing. For order.
Yes, sir.
It will come up for hearing. It will come up. What is there? What is there in order? What order? Why it is to be listed in order? Tell me.
It is a old pending.
It will come up. It will come up in the hearing list. Next.
For motion, item number 2.
Item number B.
LCR exit, no? Where is Mr. H. Sarkar? Parties shall go through 11. I don't know whether they have gone through. Next week, in the council for the petitioner is absent. List next week.
For addition, item number 3.
But this case is covered up the affairs to judgment. Once he was declared Indian, second time notice was issued. So we have brought the matter to the trial court, my lord. The trial court has rejected our prayer. No, I will go with the proceedings. Then we have come to your lordship. Your lordship has stayed the proceedings of the court below. Second proceeding. So, my lord, as per in view of the affairs court judgment, my lord, unnecessary harassment, all these things, it may be disposed of, quashing their second proceedings.
What is the first proceeding? Let us see.
Yes, first proceedings is page 14, my lord.
Oberon Bibi.
Yes, sir.
Oh, 2229.
Hmm.
और इंस्ट्रक्शन किया है सर मेरे लिए
পড়া নাই একটু প্লেস করো তার এখন নোটিশ কোন হয়ে গেছে ডব্লিউএস ফাইল করো তার রেডি করো না এই বেল তো অ্যাকসেপ্ট করা নাই ডিস্ট্রিক্ট
Page 16 is the second notice, madam.
And what is page 39 opinion?
Page 39, madam. Manjit Sharma.
The proceeding was present along with counsel file a petition number when they will tell the declare Indian national FT citing on the. What is the view of the tribunal? What did they say?
My lord, this is the view is that he will proceed, my lord. That we have annexed this that order also. We have made the application. Page 17 is our application before the court with the apex court decision. But then the page 19 is the opinion of the court below tribunal. They let us proceed with this proceedings, my lord.
এটা কি?
আবরণ বেবি এটা আমি সিলেক্ট করেছি
এটা কি দিয়ে করলাম?
small আবরণ বেবি তারপরে বেবি থেকে
Due to case back in 15.
এটা আপনি ডিসপ্লে করে দেন WS
97.
Okay.
Yes, Verma, how can you sustain this order opinion 5/10/2021?
Lordship, my brief is again missing.
Sorry,
Brief is again missing, Lordship. I don't have this file with me.
give a copy day after tomorrow.
Yes, Lordship.
It's the matter day after tomorrow on the.
My lord,
is Verma.
Copy नहीं है.
No, that file has not been
1711.
found.
I'll give, just now I'll give. এটা photocopy করে দিয়ে দেন।
Item 4,
May I please, your lordship? In earlier two occasions, I have been declared as not foreigner, your lordship. Then again notice has come. Notice on page 24 here. Yes, here is
Page 24.
24 is the notice.
You have challenged the notice.
Lordship. In earlier two occasions, I have been declared as not.
After this notice, have you approached the tribunal saying that you cannot issue notice? I am already declared Indian. Have you stated so?
Lordship.
Huh? Have you stated before the tribunal?
Lordship.
Where is it? Where is the application?
Barbelia.
You file an application, tell the tribunal to decide on this issue.
WS.
We can file as WS, Lordship.
You file the WS, say that I have already now, because that has to be decided by the tribunal also. Let the tribunal examine it.
Yeah.
Huh? Let the tribunal examine with the adjudicator. And Mr. Peer Homalane counsel for the petition also, sabka naam likho. In this petition, petitioner has challenged the notice issued by the learned foreigner tribunal number 1 Gwalpara in FT case number 3022. What?
8022
I022
oblique G
oblique
G
G oblique 11.
16.
16.
Yes.
By which issued by which the petitioner have been directed to show cause as to why he to show cause as to why on the to show cause on the proceeding initiated against him, treating him to be a foreigner. Full stop. It is a case of the petitioner that petitioner had been declared to be an Indian in earlier two proceedings, namely, what are the two proceedings? In FT case number 3881/G/11,
Lordship.
in which by an opinion dated 4/5/2013, the petitioner have been declared to be an Indian. And where is the other one?
Page 13 your lord.
Page 13. Similarly, on an earlier occasion also, the tribunal, which tribunal is it? Gwalpara.
Gwalpara.
The Gwalpara Foreigners Tribunal in FT case number 2376/G/2010 had declared a petitioner and other family members wide opinion dated 4/10/2012 as Indians. Under the circumstances, they will submitted the issuing of proceeding. Under the circumstances, initiating of fresh proceeding again, in spite of the petition being having declared foreigner, would amount to abuse the process of law. Apart from the fact that such proceeding would also be barred by principal res judicata, relying on the decision of the Honorable Supreme Court in Abdul Quddus versus Union of India 2019 so and so so and so. We are also of the view that if the present petitioner had indeed been declared foreigner, no, an Indian, not foreigner, in earlier two proceedings, the present proceeding would be hit by the principle of res judicata. However, since accordingly we direct that the petitioner will apprise the tribunal of the earlier proceeding, declaring her to be not an Indian and not a foreigner, and the learned tribunal, after considering will appear before with the relevant and file necessary documents in support of our claim, and the learned tribunal, on consideration of the said application, will first decide as to whether the present petitioner had indeed been declared to be an Indian in two earlier proceedings as claimed by her. If so, if that is so, if it is found to be correct, the proceeding will immediately be concluded in her favor, declaring her to be Indian, not a foreigner. Full stop. Full stop. Accordingly, the petitioner will appear before a tribunal and file necessary application along with the supporting documents, and the tribunal will consider the issue first before proceeding. It is only when there is an adverse finding that the tribunal will proceed against the petitioner in accordance with law, in which the petitioner will be afforded all the opportunities to contest or prove her case as an Indian, not a foreigner. With the above observation, the present petition is disposed of. Let the records be remanded. Let the LCR be remanded. The petitioner will appear before the tribunal on when will he appear?
Within 1 month, yeah.
Within a month from today.
Hello.
Item number 5 through video conferencing.
Which I guess, right?
What is this?
Lordship, in this matter, we were directed to file affidavit, Lordship, which we have done, Lordship.
None appears for the petition. Yes, somebody appearing from Arunachal. They were connected, video connected.
It's connected.
Yes. Actually, it is not connected in the with this monitor. Connected. You can see you listening. Somebody is there listening. Your video is missing. Mr. Listening, your video is missing.
Very much.
Yes, we can hear you. Yeah, we can see you.
Well, I have received a epidemic in opposition, my lord, filed by the state respondent, my lord.
Yes. So what do you want today? You are the petitioner.
My lord.
What do you want today? Any order has been passed in your favor right now so far? No.
Lordship, earlier, he was supposed to file the affidavit of taking the dusty service, Lordship.
Okay. Okay, dusty service
On
to
the
respond
private-
number 4.
Lordship.
Have you taken steps? You
My
have
lord,
taken
I
steps.
filed the epidemic also, my lord. And
You have filed the affidavit before
Yes, my
the
lord.
Itanagar bench. If
Yes,
you
my lord.
remember, we had said that you may be allowed to file in Itanagar bench. Have you filed before the Itanagar bench?
my lord,
You have filed.
my lord. And I informed my lord, council for the respondent number 4, my lord, also
Yes.
has filed Okalatnama, my lord.
Oh, I
Yes,
see.
yes, my lord.
That's very good. Who is that gentleman?
Landed council N Pada, my lord. N Pada, my lord.
Okay.
Nalo Pada, my lord.
Okay. Heard Mr. What is your name, Mr.?
L
Parme?
permit, my lord. Leasing permit.
Okay. Heard Mr. L. Parme, Lane Council for the petitioner. Also Mr. Chandran, Lane Additional Senior Government Advocate, Arunachal Pradesh for respondent 1 and 2. It has been submitted by Mr. L. Parme, learned counsel for the petitioner, that that the notice has been duly served upon respondent number 4, who is in whose favor one Mr.
Must have been.
In
Counsel name?
Nalok Pada. In Pada, my lord, in
L.
Pada,
Pada.
my
L.
lord,
Pada, learned
in
counsel.
Pada.
And he has reliably learned that one L. Pada, learned counsel,
Sorry, my lord, it is in Pada, in for
N.
next.
Pada, advocate, has entered appearance on behalf of respondent number 4 by filing Wakalanama. However, we noticed that his name is not reflected in the cause list.
My lord.
Accordingly, let the matter be listed again. When shall we list it?
My lord,
You please inform Mr. Pada also.
yes, oh, I will, my lord.
Yes, please do that. So we'll list after a week or so. What? Tell us. Huh? List after next week?
Next week, my lord, I will pray for my lord, fixed date, my lord.
Tuesday.
Anytime, fixed date.
Fix date. Give a date. Convenient to you, Mr. Palme.
Any date, my lord, last date, my lord, last week, any date, my lord.
Next week.
23rd, 23/11.
23 is okay. 23 suitable. Huh?
Okay, my lord. Okay,
Okay,
my lord.
23 list again on 23. By showing the name of Mr. N. Pada, learned counsel for the respondent in the cause list. Please inform him also. that
I
this-
will, my lord, sure, my lord.
Yes.
God bless,
okay.
my lord, I will, my lord.
Much obliged.
And in this case, have you filed any affidavit,
Lordship,
Mr.?
we have.
You have filed your
filed
affidavit.
the-
So we'll wait for Mr. Pada,
Lordship,
respondent number 4, what he has to say. Okay.
God bless, my lord.
much obliged.
Supplementary list, item number 10 for orders.
Fairly, your lordship. My lord, in this case, your lordship has earlier granted by order dated 27/10/22.
It is listed for what purpose? IA for what?
For correction, my lord.
Correction of what?
Yes, to the, earlier it was ordered that the SP border Udalguri, it should be SP border Dorong at Mongolde. Because there are due to this creation of BTC, the area has fallen within BTC. But at the time of initial stage, that it was within Assam, that is about.
What is the IA 330?
Yes, 3300.
What is 330? We don't have 330, brother, you have got. I don't have 330, so this is the one.
And address would be also changed a little, my lord, because earlier it was within Mongoldo PS, now it is Kolaigaon PS. So address and the releasing authority shall be the SP border Dorong at Mongoldo.
You have been already arrested or what?
Yes, I am in custody at
Okay.
Tesco detention camp. And the SP has written a letter. A copy has been also given to me.
Okay.
So only
So we'll
that.
make necessary correction. Okay, Han, Mr. Mahmood Lana, counsel for the petition applicant, also Mr. Sharma for the state. Sabka naam likhao. The present application has been filed for making certain typographical mistakes which has occurred in the order passed by this court on 27/10/2022. It has been submitted that though the petitioner was directed to appear before the SP border Udalguri,
Yes.
the correct official before whom the petitioner is to appear is SP border.
And not to appear, to release.
Okay, though the petitioner is supposed to be released,
Yes.
with the direction was issued to it has been submitted, though the direction was issued to the SP border Udalguri for release on furnishing a bail bond of 15,000. The appropriate authority would be SP Superintendent of Police Border
At Dorong district at Mongoldo.
at Mongoldo.
Yes.
Who is under whose jurisdiction
The earlier case was initiated.
the earlier case was initiated. And accordingly, and under whose present jurisdiction the petitioner is presently detained.
Okay.
Huh?
Yes, yes.
He is under his
Yes,
jurisdiction, right? No?
yes.
Accordingly, the order dated 27/10/2022 is modified by directing the SP Superintendent Police Border Dorang.
Dorang district at Mongoldoy shall release
Durham district at Mongoldoy
at Mongoldoy shall release the
to
petitioner
release the petitioner
from the
on
detention
furnishing
camp.
from detention on furnishing a bail bond rupees 15,000 to the satisfaction of SP Border Dorang at Mongoldoy is directed by this court is directed on 27/10/2022. Full stop.
I may be allowed to correct the address also
Full stop.
by hand.
The the Superintendent Police Border Dorang shall also take necessary steps as directed in the order dated 27/10/2022. Full stop. The petitioner is permitted to make necessary correction in the course title of the correction where
Correction address Mellors in earlier the village is same, but earlier it was Mongoldoy PS and district was Dorang, that should be inserted in the place of PS Kolego, district Udalguri.
Full stop. It has been submitted that because of change in the because the carving out of the new district of
New
Dorang.
district of Karbi, yes.
and
New creation of Udalguri district from erstwhile Dorang district.
I think we left to change party.
in view of the change in the address due to creation of new district of Dorang,
Udalguri from
Udalguri,
bifurcating the district Dorang.
after being bifurcated from district Dorang, the petitioner is permitted to make necessary correction in the course title as regards the address of the petitioner as well as also implement the Superintendent Police Border Dorang,
Yes, Yes.
at Mongoldoy.
and OC
And
Mongoldoy
also-
police station.
and the officer in charge Mongoldoy Police Station, District
District Dorang.
Dorang, as respondent number 8 and 9 respectively.
No, well, it will be respondent number 6 and 7.
No, 6 and 7 are there. Let them be there. 8 and 9 will be
New.
implemented. Will be implemented.
Now, my junior will correct it, fellow, here, just now. How much?
Stay matters, item number 7.
Matters, I'm sorry, matters, mention item number 2 matters,
What
regular.
is
list.
item number 2?
Item number 2, regular. list.
Usharani.
My name is not appears in the cause list. my
Oh,
lord.
I see. Usharani.
Ucharani.
What do you want?
Well, let's say record is received, my lord. Let the matter place for hearing, my lord.
Oh, you can be placed for hearing, huh?
Yes.
And Mr.
H.A. Sarkar.
H.A. Sorkar, Lana Counsel for the petitioner. Since the records have been received, the matter will be listed for hearing. Huh? You are on bail or something? I don't know.
No, he is already bail.
Huh?
Already
Already on-
bail is given.
Huh?
Already on bail. Lord.
Already on bail.
In this Usharani,
Yes, ma'am.
Item 2, Lordship.
item number 2, already bail has been granted.
Lordship has passed the order to list it next week, Lordship.
No.
Item two.
No, at that time he was not present.
Yes, and is on, maybe on bail or anything, no?
You need to get. No, interim primarily concerned the preliminary records. No, you have not yet got bail. Huh?
Next week, ma'am.
Next week,
Next week.
come prepared for bail. This so and so by showing the name of Mr. H.
H.A.
Sarkar.
Sarkar. H.A.
Ah.
Sarkar.
Next week. Huh?
2311. Stay matters, item number 7.
May I please do that?
Yes,
Actually, in this matter, Lordship, the petitioner wants to reduce to official witness, Lordship. And he filed a petition and that petition was rejected. That is,
same matter.
petitioner wants an opportunity to Lordship.
Matter may be fixed for hearing. Because new document. Lordship.
Documents is not new, Lordship. Documents has already been exhibited, Lordship. He wants to examine those official witness lordship, the circle officer and lordship election officer lordship. He wants lordship only one another further opportunity lordship, so that order is at place lordship 20 lordship.
Matter has already been said, lordship. May fix for hearing, lordship.
But then the official witness, they are supposed to appear. Why didn't appear? Notice. What can he do? What this petitioner can do?
And lordship, I have downloaded the lordship take consignment lordship. from the
See,
website.
according to Land Council for the petition, though the said official had received notice, they did not appear. They appear on the council file, praying for number 3. And they are the one who will be required. Procedure appearance. Since the petition in this step could not be taken last official.
And lordship, in similar case, lordship, one case lordship, this honorable has lordship given opportunity to lordship reduce evidence law.
Let it come up for hearing, lordship.
What is there to be heard, Mr. Sharma? Please. If step him taken when some use, what would the role tribunal to enforce? Yes, sir, Verma, you are supposed to file an affidavit to clarify the above issue. Please read para or order date 2/12/2021. Order, have you got a copy of the order? No. Did you? Just have a good, because it appears that in some tribunal, the tribunal insists they issue notice, official, because they are official witnesses, no?
Tribunal has a power to summon them.
Power of CPC, why can't the, yes. The official, your witness is that they have the power of the civil court to enforce attendance. Para 6, 7.
Lordship will give us little bit more time.
Hello.
File it.
2 weeks.
2 weeks is the.
Okay. Ms. Verma prays for further 2 weeks to file the affidavit as desired by this court on 2/12/2021 relating to issue of enforcing the presence of official witnesses by the tribunal. We file that so that we'll know, because see, otherwise they will be put to serious jeopardy. Okay. Okay.
2911.
Oblastment.
Item 8,
Ekram Mali.
May it please your lordship.
What is this Ekram Mali? Records have been received.
My lord, it can be taken up. I have a similar prayer that this matter may be remanded to the learned FT again.
Why?
Reason being, my lord, first thing, the petitioner herein had already exhibited the sale deeds executed by his father in way back in 1948 and 1967. But the learned FT came to a conclusion at para 11 that from the above discussion, there appears glaring inconsistency and contradiction which lead to adverse presumption that though proceedee has produced exhibit A and B, the registered sale deeds of his projected father, but there is very possibility that his projected father had left the country by selling his landed properties and used to reside elsewhere after independence and partition and before formation of separate state of Bangladesh, and thereafter again come back to India for permanently residing after 25th March 1971. My lord, these sale deeds are of 1948 and 67.
Verma, on what basis that? How can the tribunal draw such inference? For any inference, there must be basis. There's a basic premise of law.
My lord.
If you want to draw an inference, it must be based on certain evidence.
And my lord, secondly,
On what basis he will draw the inference that he might have left, he might, then everybody might have left, Mr. Verma. What to do? Yes, we are demanding.
my lord, second point, my lord, I may be given the liberty. At the time of filing the written statement, the petitioner did not have the voter ID of 1970. But subsequently, from the internet and by searching and taking help from other people from the cities, he has been able to procure the electoral roll of 1970 where his father's name appears. So he may be permitted to file an additional written statement and bring this on record, my lord. It is
Yes,
at page 23.
yes, Verma, because see, that reasoning is absolutely not based on record. So therefore, I don't think it can be sustained in law.
It may be
And the
remanded.
tribunal cannot make such presumptions.
Lordship.
For that matter, any authority, nobody
Yes.
can, that he might have left and he might have come.
My lord,
There must be some basis.
that's fine.
Okay.
The documents which my friend is relying on now, Lordship, it had
It-
not been exhibited before. And these are very old documents.
No, it has been exhibited.
Yes, my lord, the sale deeds have been exhibited.
Ah.
The sale deed, the additional documents.
Additional, of course.
Additional,
it
there
is-
is just one document, my lord, the electoral roll of 1970. It is an official document.
If you, yes. Then she will make an application, the tribunal will consider in accordance with law. No problem. What is that, your finding of the learned tribunal?
Paragraph 11, my lord.
Page number?
Page 66.
Page 66,
Yes, my lord.
para 11.
Yes, my lord. The
Har miss so and so, har so sab likho, हाँ. In this petition, petitioner has challenged the opinion dated C5/2021 passed by the learned foreigners tribunal first Nagaon in FT case number 5841 of 2021 by which
2012, my lord.
2012,
5841 of 2012.
FT case number, FT case 5841 of 2012 by which the petitioner was declared to be a foreigner. For the purpose of disposal of the petition, it may not be necessary to refer to all the detailed facts which have been pleaded by the petitioner before tribunal. Suffice to mention that in order to prove that she is an Indian, not a foreigner, the petitioner had relied on certain registered sale deeds, namely sale deed number 3257 of 1948, which was exhibited Exhibit A, and the sale deed number 5572 of 1967, which was exhibited as exhibit number B, in which sale deeds, the projected father of the proceeding appears to be seller of the land, and one Jagya Ram, one Sri Jagya Ram Sharma, LD of Sub Registrar Office Nagaon, had also appeared to prove the said exhibit A and exhibit B as DW number 3, and by producing the official register having book number 121 of 1948 and volume number 32 as mentioned, para 6 of the opinion, which reads as follows. Unfortunately, the learned tribunal, however, what is the opinion of the tribunal?
Para 11, my lord.
Para
page
11.
66.
However, unfortunately, and made certain observation, did not consider the said documents to be the basis of his claim, of the claim the petitioner to be Indian citizen, by making certain assumptions that the petitioner's father might have left. There is a possibility that his father had left the country by selling his landed property and used to reside elsewhere after independence and partition and before formation of separate state of Bangladesh, and thereafter came again to India and permanently reside after 25/3/1971. And as such, ignored the importance of the said sale deeds, full stop, as mentioned in para 11, which is reproduced and below. We have the view that as aforesaid conclusion and aforesaid conclusion arrived at by the learned tribunal is dehouse the evidence and no such presumption could have been drawn drawn without any evidence to that effect. Under circumstances, we have the view that the aforesaid conclusion arrived at by the presumption and conclusion arrived at by the learned tribunal can be sustained in law, and on that ground only the impugned opinion dated 3/5/2021 cannot be sustained in law, and full stop. Full stop. We have not adverted to other grounds raised by the learned counsel for the petitioner in this case, but we found it sufficient to remand the matter for fresh reconsideration of the matter by refresh consideration by taking due note of the aforesaid sale deeds and give due note and giving due note and the legal consequences that will be follow from the aforesaid two documents. Full stop. Ms. Agarwal further submitted that recently she has been able to, recently the petitioner has been able to obtain a copy of the vote of the
Electoral roll of 1970.
1970, which will also be highly relevant and relevant for proving his case that he is an Indian and not a foreigner, which the petitioner could obtain after the petitioner could obtain, and which after due diligence, full stop. We also view that the petitioner would be entitled to rely on such relevant documents which may come in his position in due course, for which the petitioner will file necessary application before the learned tribunal, which the learned tribunal will consider in accordance with law. Full stop. Accordingly, for the reasons discussed above, we allow this petition by setting aside the impugned opinion dated 3/5/2021 passed by the learned FT so Navang, the first Navang in FT case number 584, page 62, and the post press reconsideration, and also by the application to be filed by the petitioner for relying on the voter list of 1970 as mentioned above. Full stop. The petitioner will accordingly appear for the FT again within a period of 1 month from today, along with a copy of this order, certified copy of this order, and the learned tribunal will pass a fresh opinion in accordance with law. Let the LCR be remanded forthwith to the concerned tribunal.
Item number 9.
Yes, what is this item number 9?
Lord, if I may take your lordship directly to the opinion, my lord. Lord, page 75. Here also, my lord, I am praying for a remand because the official witnesses were not examined as witnesses.
How do you say so?
My lord, paragraph 14, page 75.
Yes.
On perusal of the Jamabandi of land, Exhibit 7 at village Anandapur under Sarupeta Circle, white dark number 481 of KP Patta number 216. This document was not proved in accordance with law and therefore had little or no evidentiary value. My lord, the petitioner has exhibited all the electoral rolls way back from 1965 onwards, my lord. 1965, 1970, 77. Relevant ones being, my lord, 65 and 70. But the Jamabandi, which proved that the land was owned by the father of the petitioner, was not proved, my lord. This is not the fault of the petitioner. The steps should have been taken by the council conducting the matter, my lord, and as a result of which the witnesses have not been examined, the official witnesses. Only
Did they make a
online copy
of time?
My lord, that was produced before the learned FT.
No,
But
did they
the
ask for
witness-
the witness to come, Lordship? They have to send the.
Exactly, my lord.
application.
It is the petitioner's counsel's duty, my lord, that a witness needs to
Again,
be
they
called,
can't
but
blame the
petitioner is
counsel,
not
lord.
aware about it.
Lordship would come to.
Re-examination of
Okay,
witness.
we'll hear it. Since the records have been received, the
And
matter
Lordship,
will be
those
listed for hearing.
voters, documents, Lordship, they have not been able to prove the father, mother, grandfather, nothing, Lordship.
Proof. Let the matter be
Maybe
posted
fixed
for
for
hearing.
hearing, Lordship.
For hearing, yes. we'll put it. Huh? Hearing this, yes, criminal matter.
Leave to oblige.
But our PPs, there were some matters which are fixed today, no? Huh? 14 hearing. There's some matters which are fixed today. Oh. No, that will fix on 17.
Their
17.
preferences are fixed on 17.
Yes, correct. And today?
Today, no such matter was fixed, yes, because on that day, others were not present.
And all these 2016 matters, hearing Subur Mondal, Shiva Paul,
Learned Council for the item number 25 is ready.
item number 25. Item number 25 is Raju Mura.
Rajamura,
Raju Mura is ready.
ready.
2017. Okay, we'll
We can
take it up.
start with files.
Are you ready with also Raju Mura? Okay, we'll take it up. Raju Mura, yes. Raju Mura, file 2017.
25.
Huh? You are still in jail. Yes. How many this is a murder,
Lordship.
page 3. Humble submissions when he returned home that night. On a morning I came there around previously accused Raju killed my son, assault him brutally, putting dead body in a gunny bag kept concealed under a bed. Whose bed?
The accused bid.
Your bed. While you are sleeping, somebody killed and brought him over. Huh?
Confessional statement is also there.
Confessional statement is there. Some quarrel taken place at the night, Lordship.
Under a bed. Huh? I also came to know that someone was present. Babu Karmakar and Buslu Mura.
These two, they were not examined.
They were not examined. It is there for prayer, good self, please. So it is based, conviction is based on confessional statement
Confessional statement is there, Lordship.
and discovery also from your own,
Actually, he surrendered.
he surrendered. But then Sharma,
At least it's a case of conversion for me, if not acquittal also.
Let us see the confessional statement.
Page 75, Lordship.
Page 75.
Yes. Below, Lordship, the last day of last month was Thursday around 10:30 p.m. while I was sleeping at my home. Mintu Kormokar stolen my mobile phone from my pocket. Mintu Kormokar and Babu Kormokar were along with me while I was sleeping. Waking up when I did not find the mobile phone, I inquired them about the phone, whereupon Babu Kormokar asked Mintu Kormokar to return the mobile phone. But Mintu told me that Jiten Mura had stolen my phone. Then I, taking Mintu along, went to Jiten's house. On our arrival in Jiten's house, we found him waking up from sleep, and on being asked, Jiten told us that he had not taken away the phone. Then Mintu and I came back to our house. In my house, Babu again asked Mintu Kormokar to return my mobile phone, but Mintu did not return it. Instead, removing his clothes, he showed me anger and attempted to strike me with a kotari. I then hit Mintu in the head and hands with a stick used for plastering lime, which was lying nearby. Mintu then fell down on the ground and blood was coming out of his head. When Babu called my uncle, the latter restrained me. I then fell asleep. The following morning, Mintu was found dead. Thereafter, I myself surrendered in the police station.
So anything wrong with this confessional statement?
Lordship, procedural lapse is not there. Procedural lapse is not there.
So he was given due
Yes, Lordship. Those
caution
three,
and
yes,
warning,
yes.
everything was. Then in that case, if that is not there, because see, when we deal with confessional statement, we always look at that procedure, whether he was given due warning, whether there was any influence, whether there was any kind of coercion, whether kind of influence, pressure from any quarter,
No, he has
to
stated
see
on
that it is voluntary, because confessional statement has to be voluntary. There should not be any element to doubt the voluntariness. Once that is satisfied, the confessional statement will stand on its own.
An extrajudicial confession is also there before the PW1.
PW1 also. Who is
Yes.
PW1?
PW informant who is father of the deceased.
Father of the deceased. Father of the deceased, in front of also he had made a statement.
He has been
Let us see that PW1 statement. PW1,
page 7. No?
please.
Page 7.
7. I know accused Raju Mura. He is my relative. This is Mintu Kormokar was my elder son. I am the informant of this case. The incident took place a couple of days prior to the Kali Puja festival in the year 2013. In the evening, one day, Mintu Kormokar went out of our house along with Raju Mura. Both of them went towards the daily market at Khumtai Tea Estate, but Mintu did not return that night. At about 4 a.m. on the following day, my nephew Babu Kormokar informed me that there had been a quarrel between Raju and Mintu at Raju's home regarding a mobile phone, and at that time he had been present there. When Babul came to inform the matter to me, his shirt was stained with blood. Babul stated that in course of the quarrel, when Raju assaulted Mintu with his hands, the latter fell down over bricks. When Babul went to lift Mintu, his shirt got stained with blood. Then I came to Raju's house and found Raju's brother Vandela. When I asked him about Raju, he told me that Raju had gone to a nearby house for consuming ganja. I found Raju in the house where he was consuming ganja. On being asked about the incident, Raju told me that when both of them were sleeping in the night, Mintu took out Raju's mobile phone from his pocket. When Mintu was asked about the matter, Mintu denied to have taken the mobile phone, and then Raju assaulted Mintu with wooden baton. Raju told me that Mintu had run away when he had released him after assaulting. Thereafter, I left the place to attend my duty. Later, Raju himself surrendered in Khumtai police station and confessed there that he had killed Mintu and putting his dead body in a gunny bag, concealed it beneath the bed of Raju's own house. I received information about the incident from the police station while I was on duty. After receipt of the information, I came to the police station. Police came to Raju's house and took out the dead bodies take in a gunny bag from under the bed. I was along with the police when they took out the dead body. Police got the postmortem examination done on the dead body. Police held inquest on the dead body. I noticed injury on the back of the head of the dead body and found the legs fractured. I put my thumb impression in the inquest report. I lodged Ejahar after recovery of the dead body. Police seized the wooden baton used in commission of the incident. The police also seized 2 gunny bags in which the dead body was taken. I put my thumb impression in the seizure list through which the 2 gunny bags were seized. I saw the wooden baton being seized. Cross. There are houses of Golendra, Gonju, Gaurimura, Renutati, Populla Ganju, Lolit, Rajwal, and others near the house of Raju. My house is 1 kilometer away from that of Raju's. Raju's mother, wife, and brother also live with Raju. Babul is my nephew. Babul and I share same courtyard. At the time of incident, Babul was married. It is not a fact that I did not state before police that on the following day of the incident, Babul had come to my house to tell me that on the previous night, there had been a quarrel between Raju and Mintu regarding a mobile phone. That Babul's shirt was stained with blood, and at that night, at the time of the incident, Babul was along with Mintu and Raju. It is not a fact that I did not state before police that when I met Raju, he stated before me that he had assaulted Mintu with wooden baton over a mobile phone. It is not a fact that I did not state before police that I noticed injury on the back of the head of the dead body and found the 2 legs fractured as I saw the dead body only when it was taken away for postmortem examination, not prior to that. It is not a fact that I have deposed falsely that Raju confessed that he had assaulted Mintu with wooden baton, that Babul had told me about the incident, that I noticed blood on the Babul's shirt, and that I had seen injuries on the back of the head and legs of the deceased. I do not know about the contents of the Ejahar. Lordship, here his other family members were also present in the same house, but none were examined. Neither Babul was examined, Lordship.
Yes. So what is your plea?
Accepted confession and statement, Lordship.
There is no evidence.
No evidence, Lordship. No eyewitness, nothing, Lordship. Presence of one person, one somewhere it is written 2 person, 1 visa is also there, but Babul's presence is very much there, Lordship.
PW7.
What?
Hostile witness, PW7.
Yes. He was
was-
one. Yes, Lordship. This PW7, page 16, Lordship. So according to them,
Jiten Mura.
yes, Lordship, they the accused and the other person took the deceased into his house as because he told that the mobile phone was stolen by him. What he refused, Lordship, this PW7. I know the accused, he is my brother. I know the informant. The incident took place about 1 year back. I heard that Mintu Kormokar had died in the house of the accused. I cannot say how the person had died. The witness declared hostile and prosecution is allowed to cross-examine him. At about 1 o'clock in the night of the incident, the accused, deceased, and Babul Kormokar called me while I was sleeping in my house. Waking up, I saw them standing in the veranda of my house. I then noticed blood coming out of the head of deceased and his clothes were stained with blood. The accused asked me about mobile phone. Then I told the accused that I did not understand what he had asked me about what mobile phone. The accused then told me that the deceased had given me his mobile phone. Then I informed him that the deceased had not given me any mobile phone. Thereafter, they left for the house of the accused. It is not a fact that I stated before police that Babu Kormokar informed me that night itself that suspecting the deceased to have stolen his mobile phone, the accused had assaulted the deceased with lathi, and as a result of which the deceased had sustained grievous injury in his person, and that thereafter coming there, I saw that the person had died. It is not a fact that I had stated before police that Babu Kormokar informed me that he had witnessed the incident. It is not a fact that since the accused is my brother, I have adduced false evidence in his favor. My house is half a kilometer away from that of the accused. I did not witness the incident.
See, in the beginning of page 17,
Yes,
they said, I didn't notice blood coming
Yes,
out from the head of the deceased and his clothes were stained with blood.
yes, Lord.
So he saw the deceased.
Lordship, but if we go by the confessional statement, according to the confessional statement, he hit it only after coming back from Jiten's house. Lordship. Page 76, Lordship, second para. Regarding
Hmm.
then Mintu and came back to our house. On our arrival in Jiten house, we found him waking. Then this previous line, Jiten house, we found him waking up from sleep, and on being asked, Jiten told us that he had not taken away the phone.
Page 76. Then Mintu.
Then Mintu and I came back to our house. In my house, Babu again asked Mintu Kormokar to return my mobile phone, but Mintu did not return it. Instead, removing his cloth, he showed me anger and attempted to strike me with a cutlery. I then hit Mintu in the head and hands with a stick used for plastering lime, which was lying nearby. So, according to the confessional statement, he assaulted only after returning from Jiten's house. Jiten's cross, he has stated that at that time he had saw blood coming out of the head of the deceased.
But then he saw the blood in the head of the deceased.
But
The
according
venue-
to the confessional statement, he hit it after that, after returning back from him.
Correct, but he's going hostile.
Yes, Lordship.
But doesn't mean that everything, see, witness is declared hostile. And because he denied it in the fact that since the accused is my brother, I have adduced false evidence in his favor. The accused is his brother. Obviously, he wants to save him. But then the fact that he noticed blood coming out from the head of the deceased and his clothes were stained with blood. Therefore, there is some corroboration. To some extent, there is some corroboration. To what extent? Because see, when a witness turned hostile, he could have avoided saying all these things. But he never did. Nevertheless, he blurted out something which corroborates. Because otherwise, how will he notice blood on the head of the deceased? The fact that he noticed, and see, deceased called me while I was sleeping. Deceased and Babul, incident, the accused, the deceased, and called me while they were sleeping. Therefore, he saw the deceased, Babul, and the accused. Three of them.
Yes.
At about 1 o'clock in the night of the incident.
That is one.
There is one.
According to PW1, Lordship, page 7, at about 4 a.m. on the following day, my nephew, Lordship,
Correct. That is
Yes.
true. There is no.
informed me that there had been a quarrel between Raju and Mintu. So, according to PW7, at about 1 a.m. he had saw. According to confessional statement, after going back from PW7 house, he assaulted. And according to PW1, at
No.
about 4 a.m.
Correct. He was informed. Later on
Yes,
informed.
informed, but
At about 4 a.m. on the following day, my nephew Babul Korma informed me that there had been a quarrel between Raju and Mintu at Raju's home regarding a mobile phone. When Babul came to inform the matter to me, his shirt was stained with blood. Babul stated that in course of quarrel, when Raju assaulted Mintu with his hand, the latter fell down over bricks. So the fact that the deceased was hit and he sustained injury, it is there. Now, who caused it?
who caused it and when?
Who caused it when? Now, the time difference is not so vast. It's the same night, maybe 1 o'clock, 3 o'clock. But then, who else would do? Except for these three persons, the accused and the
This
Babul.
is accused and Babul.
Babul. Now, Babul
Babul was not examined.
was
And
not
Babul
examined.
is
Babul
related-
also has not been made an accused. Correct?
Yes, Babul is a relative of deceased.
Relative of deceased. And of course, Babul's
Babul insisted him to tell about who had stolen the mobile. His presence is very much there from beginning, Lord.
Correct. I mean, had this confessional statement not been there, yes, you would have got a benefit of doubt. The problem is the confessional statement you made. Therefore, we wanted to examine how the confessional statement was made. He was giving due warning.
Yes,
By
Lordship.
now?
Now, this,
Huh?
magistrate was examined in
4 days.
PW 11.
So, because nobody would just confess like that.
Yes.
If other person had done it, say Babul or somebody else, huh? Or Mintu, oh, why should he own up the responsibility?
Because the dead body was in his house, veranda of his
And
house.
therefore, he could have said so only under influence or coercion. The police might have threatened, since the dead body was found under the, you must own up. But that threat is not there, that coercion is not there.
His dead, Lordship, some quarrel taken place after coming back. And when he showed and attempted to strike, then he beaten him with a stick used for plastering life. And then the blood was coming and he then fell asleep. In the following morning, he saw the dead body. It is a case of either a grievous hurt, because had he been taken immediately,
But then why should he be put in a body bag and kept? He must have
because
died.
in the morning he died. In the morning when he awake, he saw his dead body. And then Raju, Babul, instead of asking for any help, nothing, he went to inform that some quarrel. He had till then perhaps he had died.
The only thing is that you may say that there was no premeditation to murder him.
Yes.
It was out of anger or whatever, you know.
Because stolen part is
Stolen
there.
part there. Therefore, out of anger, he hit. And so he had no intention to kill, murder. There was no.
Weapon was
then-
not, whatever he found just in hand.
But it hit where? He hit it. Where he was, he hit on the head, no?
His confessional statement, he has stated that he hit it in head, but according to Babu, he had just by hand.
There's a problem also, no? Because you cannot hit on the head. You know that he is likely to cause death.
Because he had attempted to strike me with a cautery to at least, because it is in his hand. I then hit me in the head and hands with a stick, because he is carrying that cautery.
Instead of removing, he saw me anger and attempted to strike me anger. I didn't hit with the hand with a stick used for personal lying by me. Fell
Lying
down the
nearby.
ground. When I call my anger. All you can argue is that there was no premeditation.
Premeditation is not there. In fact, he surrendered in his
Surrendered.
this 164 also. He stated that he
There was no previous enmity
I
also.
am feeling guilty of my act. That is what his view.
Therefore, there was no previous enmity also. They were all friends.
Yes.
Out of anger, no, he's.
All are around their 20-22 years.
How long you have been in jail?
This is of 2013, Lordship.
How long you have been in jail?
That's from the record only, it can reveal, Lordship. Judgment from the date of judgment. Now it is, this is
Judgment is?
date of judgment is
2017.
2007, 5/5/17. Sorry, 27/2/17. An order was passed on 1/3/17. 1/3/17. Almost 6, more than 5.5 years after judgment. And prior to that incident, he was arrested on the very next day.
And he remained in jail, custody.
That I have to verify from record only. From whether he at the trial stage he was all along in jail or not. That is only from record, Lordship. But from judgment he is there.
So it is imprisonment for life.
Right.
For life.
Right.
Any judgment you like to rely on to convert from this life to part
Lordship,
2 or something like that?
husband, I have not bring lordship, but from the record lordship, there is no premeditation. It's not that he is, in fact, he had stolen or not, that is not proof, but the others evidence supported that it is by him only, because neither Jiten not this. There are some Likna in the prosecution case, they had not examined the vital witness lordship. But either there is no confession statement, I would have argued in some different way lordship, but there is a confession statement.
Yes, Leonard PP, what do you say?
My lord, first, I beg to submit, my lord, that Babul Kormokar, who was a vital witness to the case in hand. My lord, he is a cited witness as in the charge sheet. He was cited as witness, my lord, PW prosecution witness. And on a number of occasions, summons were issued to him, but summons could not be served. And my lord, number of occasions, summons were issued to his new addresses found after inquiry, my lord. But he could not be, my lord, examined. That is why he could not be examined. Now, my lord, regarding, my lord, conviction, my lord, first, the learned council has to, my lord, assail, my lord, demolish the confessional statement. My lord, confessional statement, there is no illegality in recording the confessional statement. All portion was taken by the learned magistrate, my lord. And one thing, my lord, what I submit, your lordship may kindly come to page 8 of the position of PW1. He says, when he went to inquire about the accused, his elder brother said that he was consuming ganja in a nearby place. So my lord, this is also one of his characters. My lord, page 8, my lord.
Page 8.
Page 8.
Where is
I
it?
found 1, 2, 3, 4, 5, 6. 6 line, my lord, from top.
I found Raju.
I found Raju in the house where he was consuming ganja.
Ganja.
So he habituated with ganja, my lord.
Hmm.
So maybe, my lord, under influence of ganja, he might have committed this. So, my lord, such type of, my lord, accused person should not be, my lord, taken leniently, my lord. We should respect at all. He may be a threat to the society. Otherwise, my lord, I would have, my lord, considered that this could have been brought under section 304 part 2 or part 1, my lord. And, my lord, injuries, your lordship will kindly see page, the doctor's evidence. Multiple injuries are there, my lord. Page 18, my lord.
Page
Injuries,
18.
7, 8, in the 9, my lord, injuries. Even, my lord, liver, spleen, and kidney are congested.
There is lacerated wound over left. Fracture, comminuted fracture on the left temporal skull beneath which there is large hematoma. There is abrasion right shoulder. There is bruise over left chest wall. In both arms and joining, there is abrasion over lateral stomach and small intestine, large intestine, fecal matter. Liver congested, open head injury. Injuries are antemortem in nature, time and 30. Who is this PW9?
PW9.
Profullo Ganju.
He is state worker. He took the police to the house of the accused.
we found a dead body of the person in two gunny bags kept under the bed inside the house.
The seizure witness.
Who is this Gulendro Ganju?
PW10.
Who is he?
These are the neighboring people, Lordship.
I came to know someone had killed deceased, inquest was held. Fine.
Reported witness.
Your Lordship, PW9 has stated one line that 1 to 7 line, Lordship. In the following morning of the incident, when I inquired about the incident, Babul Kormakar informed me that the deceased had ran away. Page 20. 7 line, Lordship. In the following morning of the incident, when I inquired about the incident, Babul Kormakar informed me that the deceased had ran away. The same line is also stated by the accused, Lordship, as per PW1, Lordship. When I asked him about Raju, he told me that Raju had gone to a nearby house for consuming. I found Raju in the house where he was
You are
consuming.
reading which page?
Lordship, I am reading page 20 as well as page 8. According to Raju, Raju told
I inquired that deceased had run away.
ran away.
Where have you where is it that found in
Yes, page 8, Lordship.
which line?
11 line starts from. Raju told me that Mintu had ran away when he had released him after assaulting.
Raju told me that Mintu had run away when he had released
Yes.
him after assaulting. Release him means?
And
Huh?
Babul Kormakar had also stated that he had ran away. And this Babul again told the father of the deceased that Mintu at about 4 a.m. that this happened. And the dead body was found in his house. Then why Babul is this side he is supporting the case of the accused, and again he went to the house of the deceased to inform that this happened. And all along, and one thing my learned colleague had stated that someone could not be served for PW1's evidence. They share same courtyard, Lordship. This Babul and PW1 share same courtyard. In his cross, he has stated that first.
Correct. Babul is a very key witness actually. He was not examined. He may be an accomplice also.
Yes,
He left the place, my lord.
He may be also accomplice because it may be possible to beat one person to death alone. And he is a ganjawala, the accused. He may be under influence of ganja also, but he may not be himself. So maybe this Babul, Babul might have been also involved.
Yes, Lordship, because Babul's evidence is contradictory. Somewhere he stated that he had beaten, somewhere he stated that the deceased ran away.
Brother of Raju also. Both of them, when a person was injured, why he had consumed it? In the night.
But will it be a ground to acquit you? Because you yourself confessed.
That is why I am
See,
afraid.
because this
this is a
confessional
conviction.
statement, the confessional statement is absolutely against you. That is the whole problem.
Unassailable.
If confessional statement was not there, perhaps you could have got some benefit of doubt. Maybe you were not the only one, somebody else might have been involved also.
In all probability, there is some quarrel between them, Lordship.
Yes, yes.
After beating him, he had perhaps went to sleep. So
Yes.
thereafter also this Babul may be involved with some
Involved.
quarrel with him. And
Yes.
as a result of he might have died.
Correct.
Seeing in the next morning when he woke up, he saw the dead body, and out of fear he had taken the dead body in a gunny bag and was put inside the bed, lordship. This may
Yes.
be only as I can explain,
Yes,
lordship.
there
And
is a-
then he when he asked, father asked, he at the very moment he had stated that he had ran away. But why Babul had also stated that, that is not known. Then he perhaps out of fear and all this had just he went to surrender himself. He surrendered, and he had also stated that uh, because he is
Babul and this,
feeling guilty.
in what way they are related, the accused
Bab-
and the Babul?
Yeah, accused and Babul are not related.
They are
They're
not
deceased and Babul. Babul is my nephew. That means Babul is a cousin of deceased. PW once stated Babul is my nephew. They share same courtyard,
But not with the accused.
not with the accused.
Okay.
Accused house is 1 kilometer away from Raju, this deceased house, and Babul and the deceased are sharing the same courtyard.
So no, these are all possible, but then because of this confessional statement, that is a problem.
At least lordship, premeditation is not there, and it is the weapon is not there. He had not taken any weapon. In fact, from confessional statement, in the Qatari is taken by the deceased only. What is lying near to save him and whatever, because his mobile phone was stolen, all these might have happened. And he had his conduct, lordship, taking ganja is a different issue that we have nothing doing with his care. Whether he had taken ganja at that time, that is also not there. He surrendered. He had nowhere tried.
Who is this other fellow?
This Bilsha,
No. The confessional statement,
lordship.
page 76. Third paragraph, page 76.
Mintu then,
Then-
when Babu,
Then I hit Mintu.
I then hit Mintu in the head and hands with a stick used for plastering lime, which was lying nearby. Mintu then fell down on the ground and blood was coming out of his head. When Babu, no, it's a Pahir Babul. When Babu called my uncle,
Who is this uncle? The letter restrained me.
restrained me.
Who letter restrained him?
Maybe the uncle and
Who is this uncle?
uncle maybe this is father.
Father of the deceased.
This is father, but this is father was not there at all. He was only informed as per his evidence. Because there may be the family members are staying in his house. It is not that.
No, these three prints stayed together at page 75.
The list, Mintu Kormakar and Babu Kormakar were along with me while I was sleeping. Waking up them when I did not find the mobile phone, I inquired them about the phone, whereupon Babu Kormakar asked Mintu Kormakar to return the mobile phone. But Mintu told me that Jiten Mura has stolen my phone. Then I, taking Mintu along, went to Jiten's house. On our arrival in Jiten's house, we found him waking up from sleep. And on being asked, Jiten told us that he had not taken away the phone. Then Mintu and I came back to our house. In my house, Babu again asked Mintu Kormakar to return my mobile phone, but Mintu did not return it. Instead, removing his clothes so and so. I then hit Mintu in his head and hands with a stick used for plastering lime, which was lying nearby. Mintu then fell down on the ground and blood was coming out of his head. When Babu called my uncle, the latter restrained me. So this is not very clear. This is not clear, but in the Azahar lordship, there is presence of one more person is there. Buslu Mura were present at the place of occurrence, but this Buslu Mura is nowhere mentioned. None had mentioned his name. Neither he was examined, nothing. Babu Kormakar and Buslu Mura were present at the place of occurrence at the time of incident. But it is nowhere in the evidence.
Babul is nephew of PW1.
One thing, Lordship, according to the IO Lordship, Babul Karmakar's statement was recorded. So may not be admissible, but his evidence might be there in the record, Lordship. This is not with me, Lord.
Yes.
Might have been involved. He says agrees. Each cycle of the product. Unfortunately, he saw both of them. He started thinking. Tried to stop up. When both I think he got both of them. Father accepted the father. But during that year,
What is the, Mr. Learned Counsel, what is the meaning of confession?
Confession, yes, but in the different.
Confession means admitting guilt,
Admission.
admitting the
is-
guilt.
Yes, admission. of
And
the
what
guilt.
is the, see, what did he admit? See, page 76. When I then hit Mintu in the head with hands with a stick used for plastering, para 3, huh?
Correct.
Mintu then fell down on the ground and blood was coming out of his head. When Babu called in my uncle, I then fell asleep. He did not say that he killed him. See, confession must be admission of the guilt.
Yes.
He did not admit to the guilt, actually. He hit him, he fell down, blood was coming out. So it is not that that Mintu died.
Mintu died.
Ultimately may have died later on.
He says.
No, no.
Extent that he hit.
Correct.
He had
That
assaulted
hit does not necessarily mean that he has died. When you confess guilt, confession means admission of guilt. It cannot be halfway. He has admitted to have hit, fell down the ground, the blood was coming out of his head.
But that
After that, what happened? That whether it led to death, maybe, correct? Who had then after he then fell asleep, then he may have been finished off by other person also. We don't know what see Vijita is saying. What we are trying to say is that no, we are not. What we are saying is that, see, when you say confession, confession must be admission of guilt. That is confession. Admission is one thing. Admission to certain fact is one thing. But when you say confessional statement, confession means admission of guilt. That yes, I have killed him. But this falls short of that. Mintu then fell down on the ground and blood was coming out of his head. It falls short. It may lead to his death. That is one thing. But can it be said that he's admitting confessional statement? We are not denying that his statement so recorded by the magistrate was voluntary in nature. That we have understood. But then, when you say confession, confession is admission of guilt. Confession, the difference between admission and confession is that admission maybe you admit to certain fact. That is, but that may not be to guilt, guilty con. To to convert admission to confession, he must have confessed, admitted his guilt. Then he must have admitted he committed a crime. Now, Mintu fell down on the ground, blood was coming out of the head. He may have just unconscious.
Madam.
We are just saying. So what do you say about it?
Now, confessional statement.
Yes. Confession to what?
There may be confession, madam, that is admission of guilt. There may be two parts in a confessional statement.
He has said no in 330.
In a confessional statement, there may be two parts.
Yes.
One is inculpatory,
Yes.
the other is exculpatory.
Yes.
So, my lord, by making a confessional statement, an accused may try to save him also. That will be exculpatory. And when he directly says that, yes, I stabbed him, this is inculpatory. When he says that he first attacked me and hit me in my head, and that is why I stabbed him, that is exculpatory.
No, he didn't say
Now
stab him.
here-
I hit him on the head
Yes.
with a stick used for with a
He-
line
he-
nearby. Correct.
He has hit him. He admits it.
To
And
that extent, yes.
The injuries sustained by the deceased,
Yes, to that
as per
extent
the
is correct.
postmortem report,
Inculpatory, yes, but
as-
then it does not amount to full scale admission of guilt.
that,
no?
my lord, no, that may be looked into other way. He might not have intention. My lord, when 302 is.
No. It's not question of intention. If you read this sentence, this para 3, does he admit that he has killed him? He said he didn't say. Murder, did he murder him?
That
Because
is
with the
why.
intention to kill, cause a death.
Your lordship,
His
your lordship
confession
has
itself will be
noticed.
there for under 304 part 2. Because he said there is a aggression from the other.
This is exculpatory because he says that
No,
he
Mr.
tried to
Das,
attack-
suppose we go by this confession, then also it's not a case of 302. That is what,
No, but there is one thing.
because he
When-
says that he first,
Yes,
there is certain
yes, I
quarrel
understand.
between them. So he describe it. So in that view of this, if we go by the confession itself, will it amount
This-
to
Your
302?
lordship may say that this may be a case
Yes.
of 304.
Because he
I'm
himself
coming to
says.
that. I'm coming to that. Now, my lord, this is exculpatory. He says that the deceased tried to injure him, strike him with a kotari. Now, deceased was falling there. His dead body was there. No kotari was recovered by the police. So this is exculpatory statement. Now, there is apex court judgment when we have to take the entire confession statement as a whole. We cannot take partly. Now, suppose this exculpatory statement is highly improbable, then your lordship may disbelieve it. Because there is no recovery of kotari, there is no injury in the body of the accused. So this is a story cooked up by him at the time of making his statement, a confessional statement, to save his skin. So this is not, this is highly improbable. No other witness is saying that.
No other witnesses are there.
No, even Zitan was also there. Zitan, he was declared hostile, but he does not say that any injury mark was there in the body of the accused.
No, accused do not say that I was injured. He says he attempted.
Yes, in the attempt also some injury may be, or even then, supposing he failed in his attempt. But the kotari could have, it is in his house. The kotari could have been handed over to the police. No kotari was there. So that is why with all respect I submit, my lord, that has to be taken as highly improbable. And when Zitan's house, when the deceased was brought to Zitan's house, at that time itself he was injured. Zitan says, when he came to my house, the blood was coming out from his head. That means already he was beaten. And after going back from his Zitan's house, he was again beaten. And that is why multiple injuries.
But
Other-
correct, but your version is inconsistent, no? You say he was injured earlier, again he was beaten up, but in his confessional statement, he does not say so.
No, that has to be-
Therefore, it is not consistent. So if it is not consistent, the defense would like to take advantage of that inconsistency.
Otherwise, I would have.
Now we are discussing. See, we are just discussing.
I know the heat of the moment these things happen in the tea gardens.
In fact,
And
Lordship,
also he did not say, following morning Mintu was found dead. He did not say who had hidden it, who had put it in a gunny bag.
one died, one fell asleep. The only person who was awake was Babul Kormokar. And Lordship, one more thing, I must, PW1 Lordship may kindly take up. If we leave this confessional statement, he had not even used any weapon also, Lordship. According to Babul Kormokar, Lordship may kindly take up page 7, last 2 lines.
Yes.
When Babul came to inform the matter to me, that is PW1, father of the deceased, his shirt was stained with blood. Babul stated that in course of the quarrel, when Raju assaulted Mintu with his hands, the latter fell down over bricks. So if we leave the confession statement, no weapon is used by this person accused. That is the evidence of Babul. He fell down.
Over bricks.
Yes. So abrasion may be because of that also. So whether he actually had used this beaten or this is by Babul, he forgot and in the morning he admitted. That is also.
Anyway, that is a hearsay evidence in the sense that it is a Babul statement. There's a whole problem.
Babul
Not
is
because
person.
Raju himself did not see anything. This is what Raju was informed by. I am Raji Kormokar, na?
Yes,
So what was informed to him by Babul?
Babul was present.
Yes. So Babul is the key person. He is missing. Actually, we could have given a benefit of doubt, but for the confessional statement. But again, confessional statement is not really a confessional to the fullest, in the full sense of the term. Because confession, when you make a confession, you must admit the guilt. What is the admitting of
His
the guilt?
guilt is up to that much.
Up to only hitting.
Then he has no knowledge what happened later.
How he
But
died.
that has resulted in, his heat has resulted in death, my lord.
Correct.
that
You
is
may,
sufficient with all respect,
that is a kind of
Regarding
presumption you will draw.
Right.
You can say there's a reasonable presumption if we hit somebody on the head, blood oozing out, most likely he'll die.
In that case also if we go by Babul,
Babul.
he had not hidden.
Hmm.
Only that he had praised left.
Therefore, perhaps it will come under see 304 part 2.
My lord,
When he hit him on the head, he may have
Yes.
knowledge, the knowledge that he will likely to cause death.
at the
but-
beginning itself, I said, my lord,
Yes,
that I
correct.
would have considered for 304 part 2 for this case. But this ganja,
Ganja,
This-
ganja also see,
His
well,
character
after
is
conjunction,
ganja is a favorite thing for some of the great devotees of some.
Lordship, we may
Ah.
say that seeing
On
dead body.
come Shivratri and you will have a lot of ganja flowing around.
my lord may consider 304 part.
Ganja is not a
And
very,
from his statements of the confessional statement, it appears that he had no intention. Because after that incident, he slept.
he slept. He didn't
He
run
went for
away.
sleep. Perhaps he was under the impression that some injury has been caused, he will go now. My lord, I lift
He
your
was in
words.
a state of bliss after consuming ganja. Then okay, you'll hard miss. Dictate it. You want to write? Okay then.
My lord, may I leave for 2 minutes? My lord? I'm
Okay,
coming.
my brother will write the judgment. Okay. Judgment reserved. Hard and CAV. Now give it to brother.
Obliged.
Any other matter? Yes, any other matter? Yes, next item. Huh? Anybody who is ready? 19.
19, I'm ready.
Pradeep Bhorali.
Yes, my lord.
Okay. 2016 matter. Yes. Let us see if you are ready. Yes, Lanar PP, you have document, the paper with you, paper book. 19 years. Pradeep Bhorali. Yes.
You may read the FIR first, my lord.
Pradeep Bhorali.
The FIR is at page 4. Well, the accused is the relative, brother of the deceased.
Pradeep
Really?
Bhorali. FIR page.
Page 4, my lord.
I have, who is the complainant? Dineshwar Bhorali.
Complainant is a villager, my lord.
Villager.
He's a
Humble
villager.
submission. I have recognized the dead body recovered on from Dholi River, today of my elder brother's son, Orup Bhorali. I have learned from some Bhorali, Bhorali had a quarrel with Pradeep Bhorali
Yes.
and Sri Manoj Bhorali. And I have also learned that they had killed Sri Orup Bhorali and threw the dead body. Therefore, so who are the eyewitnesses? Any eyewitness?
My lord, there is a child witness, my lord.
Let us see the child witness.
Child witness who was the eyewitness, my lord.
Yes.
But my lord, his 164 statement was not recorded. He deposed in 161, my lord, before the police that the incident happened in front of him. But my lord, the 164 confessional statement of the eyewitness was not recorded.
What is meant by confessional statement eyewitness? 164 is not necessary. 164 is for confession by the accused, but it is not necessary that the evidence of witnesses have to be recorded on 164. That is a strategy adopted by the police so that he does not deviate. Later
But he
on.
turned hostile, my lord, in the,
Who?
the eyewitness.
Let us see the eyewitness.
See, my lord, page 34.
Page 34. The child eyewitness.
Yes, my lord.
Age 14, Manoj Bhorali.
PW 11, my lord, page 34, page
Hmm.
14. On oath, accused Pradeep Bharali is my father.
Oh, his father.
Yes.
This is Orup Bhorali, is my
This Arup
uncle.
Bharali is my uncle.
The incident took place 3 years back. Present, I am staying with my father.
Yes.
Prosecution private declaring his tweet and semi allowed, hence cross-examination.
Yes.
It is not a fact that I stated before police that no. So this is the
It is not a fact that I stated before the police that on 14/7/2011 during night, quarrel took place between Pradeep Bharali and Arup Bharali in the courtyard of their house. And in that quarrel, Pradeep Bharali, by inflicting lathi blows, made Arup Bharali unconscious and lifted his body therefrom to the bank of river Dholi, and thereafter Pradeep Bharali by a dove chopped off his head.
okay, very well. The child witness, the child is the son of the accused.
Yes.
So okay. So ignore this. Let us ignore this. You mean to say there is no other evidence? There is no other evidence.
No other evidence, my lord. One eyewitness is there, my lord.
Let us see
Who
that.
resides, no, not eyewitness, my lord, he's a neighbor. My lord, but he has stated that he had not heard any quarrel on that date. My lord, that is PW 7. My lord will see PW 7, page 23. And the manner in which, my lord, the hostile witness, this evidence has to be taken, my lord, that is also not, when I will rely on your judgment, my lord, page PW 7 is, my lord, page 23. Because, my lord, the entire thing is that, my lord, some quarrel took place. And this PW 7 is, my lord, is a neighbor who is residing just, my lord.
And what is
near
the basis of conviction by the learned trial court?
Circumstantial evidence, my lord.
What are the circumstances? You last seen?
My lord, there is no other, my lord,
Then let us read what the learned trial court says that
No.
about this, because if you say that there is no evidence, let us see on what basis learned
No.
trial court convicted you.
my lord. Note page 57, my lord, paragraph 23 is the conclusion reached by the trial court, my lord. From the aforesaid discussions. From the aforesaid discussion, the following circumstances have been found to be established by the prosecution. Accused and the deceased stayed together in the same compound, although in different houses. Accused and the deceased had a quarrel on the night of 15/7/2011. Now that is doubtful, my lord, because the fact of quarrel, my lord, who is PW 7, who is the neighbor, my lord, who is residing at the place of occurrence, he said that there was no quarrel. After the quarrel, the deceased was not found and he was found to have been disappeared. There is no intimation about his disappearance by the accused and his family members, including his son Manoj Bharali, and they did not even search for the deceased Arup Bharali. My lord, here what is important, my lord, the date of incident of quarrel was 14/7, my lord, and the FIR was lodged, my lord, after the recovery of the dead body. So, my lord, from the date of the incident of quarrel, 2-3 days, there was no FIR regarding missing information. My lord, then the dead body of the accused Bharali was found from Dholi River in a decomposed state, with his head been severed. Arup Bharali was declared to be dead for about 3 to 7 days by 18/7/2011 by the doctor. Accused Pradeep Bharali absconded when the dead body of the accused Bharali was recovered from the Dholi River. The son of the accused, namely Manoj Bharali, showed the place where the dead body was thrown in the bank of Dholi River, and the IO drew the sketch map with index according to his disclosure statement. Accused was apprehended by Tiok.
Just a minute,
my
you
lord.
see, confessional statement of Manoj Bharali, who is the son of accused, and his present Manoj Bharali confessed a quarrel took place. Let us see the statement.
Is 161.
No, statement made before the,
Police, my lord.
no. Page, come to page 48,
My lord.
somewhere in the middle of the first para. Page 48, somewhere in the middle, first para.
Yes.
He was also present at inquest of a dead body on night of so. And the police brought Manoj Bharali, who is the son of accused, to his house, and in his presence, Manoj Bharali confessed that a quarrel took place between his father, Pradeep Bharali, and the deceased the accused.
That is, my lord, not, this is a police, my lord. This
No,
is
no.
police.
Let us see. The police. No. Let us statement of. Let us see read the statement of
Yeah,
Dineshwar Bharali, PW1. What does it say?
Page number 8. Page 8.
Page 8, huh?
Yes, my lord.
I know the accused person at dog. He is my nephew. Deceased Sarvara was my nephew. He is the brother of accused.
I reside.
I reside on Farnham house. The occurrence happened in the night. On the next day of the occurrence, we heard that quarrel happened at the house of the accused on the previous day, and accordingly, I visited the house of the accused on the next day of occurrence. While I visited the house of the accused, I did not see Arup Bharali, and after 2 days at Dholi River, one dead was found. The dead body was headless. While I went to the bank river, then I noticed the body drag out of body and identified the dead body as my nephew Arup Bharali. I was present at the time of inquest. On the night of recovery, the police brought. On the night of recovery of dead body, the police brought Manoj, who is the son of accused, to my house, and in my presence, Manoj confessed that quarrel happened between his father and the deceased, as a result of which the accused father committed murder of the deceased and then brought the body to Dholi River.
Yes.
See, this is that
Yes.
what he narrated. That is what the this is the extrajudicial confession made by this son. No? Committed murder, descent, brought the body to Dholi River and then chopped the head of the deceased and threw in the Dholi River after tying bricks at the Wai River. Manoj confessed that the brick were brought by him as instructed by the accused. So there is a extrajudicial confessional statement.
Yes, my lord.
Hmm.
But my lord, he denied everything in his, after being turned outside. My lord, as to the incident of quarrel, my lord, PW7 Nandeshwar Bharali, my lord, his house is near as reflected in the sketch map. He said there was no quarrel. PW7 is 23.
Page 23.
Page 23, my lord, he was the person who was staying near the place of the occurrence.
I know Pradeep, accused Pradeep Bharali present. He is
resides
inside my
near
house.
my
I know also Arup Bharali, his younger brother. The incident occurred about 1 year back. On the day when I was playing my residence, I came to know regarding that on the ceremony. I came to know the accused had a quarrel. I came to know, yes, I came to know that accused
Yes.
Pradeep Bharali had a quarrel fight with his younger brother Arup Bharali and that Arup Bharali was no more. So he says, when I went to the house of Pradeep Bharali, the deceased was not in his residence.
Yes.
So he knew that there was a fight, quarrel.
Yes.
Then
My lord, will see page 85.
I
this
informed the
sketch
police
map.
that the accused did not find Bharali. Huh?
My lord, and in the cross examination, he says, I did not see or witness the incident.
Obviously, he did not incident. That incident he will not see.
So quarrel, he has not, my lord, he heard the
I
quarrel.
came to know that
came to
accused
know about the
Arup was a quarrel with his and that Arup was no more.
My lord, his house is near to the place. Page 85 is the, my lord, sketch map. Nandeshwar Bharali's house is just, my lord, near Arup Bharali's house. Page 85 is the sketch map. And 14 was the date of quarrel, my lord, and 15, 16, and 17. No FIR was lodged. It was only after the recovery of the body that the FIR was lodged. My lord. My lord, as to the identification of the body also, my lord, there is a doubt. In the medical, the evidence of the doctor, my lord, there is discrepancy. Because it was a headless body, my lord, and from the original photographs, my lord, it is revealed that the hands are burnt.
Let us read what the trial court says. PW4, let us see what PW4 says.
My lord.
Hmm. See, I made Manoj Bharali, who is the son of accused Pradeep Bharali. Manoj Bharali disclosed in my presence that his father cut Arup Bharali and then threw the dead body. He stated by means of the so was severe and the weapon was thrown at the Dholi River by the accused. I also know Dineshwar Bharali, who is the uncle of accused and deceased. I also testify in the case against Manoj. I also testify in the case against Manoj Bharali, who is pending. In the said case, I said I have no knowledge about the occurrence while Manoj Bharali gave statement at Puli Board police station at the time I was present. I cannot remember now whether Dineshwar Bharali was present at the time or not. It is not a fact that Manoj, it is not a fact that Manoj did not stay before me that accused severed the head of the by means of dao and threw the dead body along with the weapon. The problem is that Manoj Bharali disclosed in my presence that his father, I visited Hawaiian police, no. The problem is that even if Manoj Bharali had disclosed, made the statement, if it is made in a police station,
Presence of police.
huh?
In presence of police.
In present, then it is immaterial, then it can't be taken into consideration. That is what Evidence Act. No confession made by a person while he is in the custody of police officer. So he was the child was detained, no, by the police at that time, no, so in the police station. While he is in the custody, whether he is in by arrested or not is immaterial. He was in the custody of his statement was in the police station, while he was also one of the accused, juvenile. It become therefore it can be considered also. Then if there nothing is left, then no. The police brought Manoj Bharali, who is a son, to his house. In his but then it was brought by the police.
Yeah, he was brought by.
It was therefore it was in the custody of the police. Well, he visited the police station when police met Bharali. So Atul Dotto, government Gaumbura,
Leading to discovery is there.
Hmm?
Leading to discovery is there.
No, or the discovered or
As
earlier,
per evidence of IO.
discovered earlier. Some other got the information from the police. No, it is not leading to this criminal. After the dead body was recovered, then the FIR was launched.
PW5 deposed the Orup was last seen on 13/7, but last seen with whom? PW5 had deposed that Manoj Bharali had showed the exact place. PW5. Dilip Bharali. I know the accused. His name is Pradeep Bharali. I knew that this is Orup Bharali. I was. And that this is Orup Anno, accused both sons of my board Deota. They stayed together. When I told there was a dead body in the river, I looked. I wasn't told that there was a dead body in the river. I looked it from a distance. Police lifted and took away the dead body. I came to know that Orup Bharali dead body. And took him. Police apparently accused Pradeep Bharali and the son and took him to our home. At our home, he told we were stuck. After police had apprehended Pradeep Bharali, they took him to the bank of river 2 days after they were recovered from. He also showed the dao with which he had cut the head. However, police could not recover the head and the dao even after engaging fishermen. My father Dinesh loves the Ejhar.
PW5 also stated that there are houses of Nandeshwar Bharali, there are 3 more persons situated nearby. Those witnesses were not examined. Mainly is the quarrel, incident of quarrel, whether that had taken place, my lord. The cross, my lord, PW5 has stated.
See, page 57, para 23. There is a finding of the learned
My lord, yes.
trial court. But how much is there based on evidence?
The incident of quarrel, my lord, the quarrel was of such an extent, my lord, leading to, my lord, beheading of the head. Definitely there would have
Accused and
been-
deceased had a quarrel on a night of 15/7.
This is not
What is the basis of
established.
that? What is the evidence?
only PW7 is there, my lord, but in cross, he only says he had heard the quarrel, he came to know about the quarrel.
PW,
PW7,
page,
page, my lord, 23. On the date of the incident, I was present
I
in.
came to know that accused Borali had a quarrel fight with his younger brother and that Arup was no
I
more.
came to know that is the hearsay, my lord. When I went to the house of the accused, his deceased Arup Bharali was not in his residence. But the incident took place on 14, and then after 3 days, there was no missing information lodged by any of the witnesses, my lord, in spite of knowing that Arup Bharali was not in residence. And then in the cross-examination, he clearly says, I did not see or witness the incident. Matlab, PW5 in the cross-examination stated that the houses of Nandeshwar Bharali, Rineshwar and that of Someshwar are situated nearby the house of Pradeep. In the sketch map at page 85, that reveals that the houses were there nearby.
Yes, learned PP, what are the circumstances which would implicate him, the accused? Because circumstantial evidence. There was no recovery of the dead body at the instance of the accused. It was just recovered by the villagers.
No, at the instance of his son, I think.
No, instead his son merely stated that this is the place where he was cut. But it was, what is that, it was at the instance of the son, the dead body was recovered? No, there is no evidence.
I has stated, because.
Something based.
Why is IO has stated? So,
PW,
please, IO.
but I do not have the paper book.
Are you on page
I on
29?
PW,
29.
Please,
PW 10. PW 10, page,
PW 10.
29.
29.
I was walking, rushed to the place, reached the place, so dead body of a male with wearing blue color pant, torso, big was tied, was facing upward. So by the time he saw the dead body,
He says, the PW 10 says the accused
32,
Pradeep
page
led
32.
us to the place of occurrence, which was the
As but one
same
today,
place
accused
where
Pradeep Bharat.
we recovered the dead body.
accused Pradeep Bharat led us to the place of occurrence, which is the same place where he recovered a dead body.
This is not
Without the, which was
Without the
already
severe
shown to us
head-
by son of the accused themselves.
No. Accused led us to the place of occurrence. Later on, no.
Later on.
Oh, but body was already recovered. Then therefore it loses the
But it is the
significance.
same place, Milo.
That doesn't mean anything. It is not recovery.
There is
What
no
is
recovery.
what is admissible under section 27 is a statement which leads to discovery of fact.
Discovery of fact. But that
Which-
fact, he says, Milo, this is the place of occurrence. This
How
is
the-
where I was led to Milo that place.
So how is
The
it
place of
relevant?
occurrence-
How is it relevant? Because it doesn't lead to any discovery. It is subsequent. Had it been done earlier, it was admissible. Then anybody can say, oh, that it does not, because this is a statement made under the police custody.
Yes.
Statement made under the police custody will be only admissible when it leads to discovery. It doesn't lead to any discovery. Discovery of what?
In the sense, Milo, the plane, that body was recovered, and he also says that, yes, here
No, that can be admissible.
the same place, Milo.
No, same place. The police can always do that.
They will take him to same place.
If it was done before, yes, then the police were led to the place, then the police search, then they found, then it will be relevant.
Discovery was already done.
Therefore,
But he confirms
section
it.
27 will not be applicable.
He confirms it, Milo.
No, confirmation is not that law does not contemplate.
That is true.
Confirmatory statement, law does not contemplate. So what is that then? There is nothing, no evidence then.
And the medical evidence, my lord, says that death is due to, my lord, the deceased has deep burn injuries. My lord, you see the
Burn
original
injuries.
photographs, my lord, it's a headless body. The hands are deeply burned. So whether he has died somewhere else, and then my lord will see the deposition of the doctor. And
So
there is
that burn injury also not explained.
The
Because,
previous day quarrel was there.
quarrel was there, but then after quarrel, they burned him, then they cut him. There is nothing that they just cut him.
Extrajudicial confession. There also there is no question of side.
Burning also, even that extrajudicial confession 161, though we cannot rely on it, but there is nothing, no mention to the burn.
And actually, during the course of quarrel, what happened, nobody
Nobody knows.
knew. Only when this PW one, he visited on the next day, next morning.
That doesn't mean anything.
He said, but he did not find him.
It doesn't matter. He may have gone out. There is no. Call somebody.
And my lord, in the evidence of the doctor, my lord, at one place he is referring to male headless body, and in the next page, my lord, it is well-built adult female blackened by whole body burn. My lord will see the statement.
Female or male?
My lord will see the statement of PW9.
Forensic doctor.
Huh?
Report of copy paste. What is the PM report?
Call somebody. Stenogram.
My lord, the PM report is at page, it is there, my lord. Page 69, my lord. Here also, my lord, I think. The team report says, the male headless body.
Male, na?
Yes.
There might be some typing.
No, no. Check it. No case.
Yes, done it.
Huh?
Yes, done it.
Yes, done.
Is
One thing, I'm ready. The executive magistrate, my lord, who identified the dead body, he was also not examined.
You are the amicus in this case, Mr. Sharma?
My lord,
You are amicus.
my lord. Earlier, there was a councilman, but he was not appearing, so I was
Okay,
appointed. My lord.
okay. And Mr. H. Gupta, learned amicus for the appellant. Are also learned PP. Mr. Das,
yes.
learned additional PP for the state. The present appeal has been preferred against a conviction in the conviction under section 302 IPC. As well as for offense under section 201. 201?
201, my lord. This is for hiding it.
Make it disappear, huh? 201. Causing disappearance. 201 IPC. By judgment order dated 17 March 2016, passed in
Case 43.
passed in session case number 111 within bracket JJ dash within bracket J dash J of 2011. Arising out of GR case number 1021 of 2011 and Pulibar police case number 195 2011 by the learned Session Judge Jorhat. The conviction is primarily based on circumstantial evidence. Though we also find evidence which indicates clearly which points to the guilt of the appellant, unfortunately, in our view, the same falls short of the legal requirement for conviction of the appellant based on circumstantial evidence. Before we deal with the submissions to advance, we'd like to briefly refer to the facts in brief. An FIR was lodged on 18/7/2011 by one Dineshwar Bharali, who was examined as PW1 before the Pulibar police station, alleging inter alia that on a previous day, on 17/7/2011, a headless dead body was recovered from the Dholi river, which was identified as that of one Arup Bharali, the son of the elder brother of the complainant. It was mentioned in the complaint that he learned from reliable sources that on 14/7/2011, the deceased Arup Bharali had a quarrel with Sri Pradip Bharali and Manoj Bharali, Pradip Bharali, the appellant herein, and Manoj Bharali in the night, and both of them had committed, had murdered him, and thereafter threw the dead body after threw the dead body on the river, in the river after cutting off his head. On the basis of the said FIR, lodged, a police case being Police Board PS case number 194 of 2011 under section 302/34 IPC was registered. On completion of the investigation, charge sheet was filed against the present appellant. Since the other accused, Manoj Bharali, was found to be a juvenile, he was proceeded before the concerned juvenile justice board, of which we are not concerned in this appeal. The prosecution examined as many as 11 witnesses. And also proved the documentary evidences, including the post-mortem report. The report. Stop. The appellant also on being examined under section 313 denied the allegations. Denied the allegations. Full stop. Next para. The learned trial court on a basis on appreciating the evidence on record, however, convicted the appellant under 302 IPC as well as section 201 of the IPC and sentenced him to undergo imprisonment for life by the impugned judgment order. As mentioned above, the conviction of the appellant is primarily based on circumstantial evidence, which can be clearly ascertained from the decision of the learned trial court as contained in para 23, which is reproduced here and below. Para 23, page 57. The learned trial court held that the aforesaid circumstances have been duly proved against the appellant and accordingly convicted. Duly proved on the basis of evidence which have been on the basis of evidence adduced by the prosecution and accordingly convicted the appellant. As we examine the aforesaid finding of the learned trial court, we will also briefly refer to the evidence which have been relied upon by the prosecution. Number one, as mentioned above, the prosecution, Dineshwar Bharali was examined as PW1, who lodged the FIR and also identified the headless body of the deceased Arup Bharali. He stated in his evidence that he resides about 1.5 furlong away from the house of the accused, and occurrence took place in the night of 15/7/2011. He stated that on the next day of occurrence, he had heard that a quarrel had taken place in the house of the accused on the previous day, and accordingly, he visited the house of the accused, but did not see the deceased Orup Bharali. And after 2 days, a dead body was found in Dholi River, which was a dead body, which was headless dead body was found in Dholi River. And when he went to the river bank, he noticed that the police had dragged out the dead body, which was identified as that of his nephew Orup Bharali, the deceased. He also stated that on the night of recovery of the dead body, the police had brought Manoj, who is the son of the accused, to his house, and in his presence, he confessed that the quarrel had happened between his father and the deceased, as a result of which the accused committed the murder of the deceased and then brought the body to Dholi River, where his head was chopped off and the dead body and the body is thrown into the Dholi River after tying bricks at the waist of the dead body. He also stated that Manoj had confessed that the brick were brought by him as instructed by the accused, that is his father. The next witness examined was, what about PW2? Who's PW2?
He is also the villager. My lord.
The next witness examined was one Dulon Das, who was present while the inquest was held.
Yes.
But in the cross-examination, he stated that he did not see the dead body. He did not show the dead body to police, nor could he identify the dead body. Next witness who was examined was one Durlab Das as PW3, who was a witness to the inquest report. The next witness was Atul Dotto, as examined as PW4, Government Gaumbura, who stated that he attended the police when he was called there, and in the police station he met Manoj Bharali, the son of the accused, the appellant, who disclosed in his presence that his father had cut Orup Bharali and threw the dead body at Dholi River, and that the weapon of offense was also thrown in the river. The next witness examined was Dilip Bharali as PW5. Who was a neighbor. No, he was a neighbor, no?
Yes, my lord. No, he's a relative. My lord.
What's a relative?
He's a relative.
He was a witness to the recovery of a dead body. He also stated that the police had apprehended the Pradeep Bharali's son, Manoj, and who was taken to his house. And at his house, they said Manoj stated that his father had struck the deceased with a lathi and he helped him. And after his father had taken the dead body to the Dholi River, where his father cut the neck, and after the dead body was thrown in the river. He also stated after his arrest, the police took him to the Dholi River. And he also stated that after his father Pradeep Bharali was also arrested by the police, he was taken to the bank of Dholi River where he showed the place he had cut up Arup and thrown the dead body. What is this? Page 20, he also showed the dao with which he cut the head. However, the police could not recover the dead in the arm engaging fishermen. What is this? Huh?
No, if the object was not recovered, what he has, maybe that something of this sort was shown.
Okay. Anyway. However, the police could not recover the weapon of crime and the head which were thrown in the river. The another witness which was examined was the neighbor neighbor Nandeswar Bharali, who stated that he came to know that the accused Pradeep Bharali had a quarrel with his younger brother Arup Bharali and that Arup Bharali was no more. And when he went to the house of Pradeep Bharali, he did not find his brother Arup Bharali in his residence. And a dead body of Arup Bharali was recovered in Dholi River after about 3-4 days of the date of incident. PW8 is one Vipul Das who was a witness to the recovery of the dead body without the head. PW9 is the expert witness who is the person who performed the autopsy on the dead body of Arup Bharali, who found the following injuries on the body. Page 27. Wounds position size, not everything. Scalp not present. Brains not present. Decompose motion. You mentioned that there is some burn injury. Why is it?
Yes, ma'am. Well, it is
Page
page 28.
Page 28.
The deceased had deep burn injuries.
Where is it?
In the third line from the
Okay.
bottom.
Okay, then you type page 27 to 28, for finding. In his opinion, the death was instantaneous, resulting from chop injury to the neck. He however also mentioned that the deceased had deep burn injuries. PW10 was the officer, the investigating officer who conducted the investigation. Who stated it was the accused. We'll quote all this.
Will be done female can by whom will be bound. These has been taken from something else. That's not these banners and cookie paste to the
He stated that the accused Pradeep Bharali, appellant Bharali had led the police to the place of occurrence, which was the same place where the police recovered the dead body without the severed head, which was already shown to them by the son of the accused, namely Sri Manoj Bharali, on the basis of which the IO prepared a sketch map. PW1, PW11 is Manoj Bhorali, the son of the appellant. He was declared hostile by the court at the instance of the prosecution. In a cross-examination, he denied having stated before the police that on 14/7/2011, during the night, a quarrel had taken place between his father and Arup Bhorali, and that his father had inflicted lathi blows upon Arup Bhorali, rendering him unconscious. Thereafter, his body was lifted to the bank of River Dholi, and his father had chopped off the head of Arup Bhorali with a dao, and thereafter threw the body and the severe head to the river. He also denied having stated in presence of Nandeswar Bhorali, Nandeswar Bhorali, PW7, that he would lead the police to a place where the occurrence had taken place, and where the dead body, where the severed head and body were thrown by Pradeep, by the appellant. He also denied that his father had confessed before the police that he had killed Arup Bhorali with a dao and severed his head. We have also gone through the statement made by the appellant under section 313, recorded under section 313 CRPC, when the appellant was examined by the court, where he had denied the various incriminating materials which was brought on record. And stated he had been falsely implicated.
My lord, the question number 1, in the answer to it, my lord, we'll see for him. Question number 1, answer to that.
He also stated that he was not present in his house on the day of occurrence, and he has been falsely implicated. There is no other, he did not say anything else.
I do not know for what reason my son has deposed falsely against me.
And he stated he didn't know for what reason his son had deposed falsely against him.
Lord, he was
But-
hostile.
He was
Son-
hostile.
So this question
But he did not say anything. He did not make any, he did not also make any statement, giving any further statement, except for denying the allegation, denying the allegations made against him, and stating that he has been falsely implicated. He also declined to lead any evidence. The learned trial court, however, on the basis of the evidence, came to the conclusion that the appellant and the deceased had a quarrel in the night of 15/7/2011. Prior to the occurrence. In fact, this is one of the circumstantial evidence relied upon by the learned trial court in convicting. However, we are unable to find any evidence to show that there was indeed a quarrel between the appellant and the deceased on the night of 15/7/2011. What we have noted is that the PW, what is that he heard? No, is that PW? On PW1, stated that on the next day of occurrence, they heard that a quarrel had happened at the house of the accused and the accused on the previous day. In other words, this evidence is not a direct evidence of any quarrel which had, if it had taken place between the appellant and the deceased. It is merely an hearsay evidence based on certain, and it has not been clarified as to whether the said PW1 himself heard the quarrel. Similarly, though PW7 also stated that in his evidence that he came to know regarding he came to know that the accused Pradeep Bharali, that the appellant had a quarrel fight with his younger brother and that Arup was no more. It is not mentioned as to the source of his knowledge, as to whether it was a direct knowledge having heard or seen the appellant quarreling with the deceased. Under the circumstances, we are not able to give too much importance on the aforesaid evidence to be the basis for the finding by the learned trial court that the accused and deceased had a quarrel on the night of 15/7/2011. Next para. The learned trial court also noted that though the accused, though the appellant and the deceased were staying together in the same compound, although in different houses, there was no intimation about the disappearance of the deceased by the accused, by the appellant and his family members, including his son, and they did not even search for the deceased Arup Bharali. Certainly, the aforesaid act of the appellant and his son cannot be said to be normal conduct if a person, close member of the family member, is found to be missing. Yet that cannot be the basis or evidence to implicate them in as much as it does not indicate any direct knowledge of the appellant with the fact of missing of the deceased person. The learned trial court also had observed that the appellant Pradeep Bharali absconded when the dead body of the deceased was recovered from the Dholi River. While this aspect can be taken into consideration as part of the, could also be taken into consideration as part of the chain of events, yet we have to examine whether there are other evidences on record which form a chain of events leading to the irresistible conclusion that the appellant is the author of the crime. However, what we have noted is that apart from such suspicious behavior of the appellant, that is not reporting of the missing of the deceased, absconding when the dead body was recovered, or making false statement about the disappearance of the brother during statement recorded under 313 CRPC, section 3137, as observed by the learned trial court. We have the view that such acts do not and cannot constitute the basis for conviction, as these are based on suspicion, as these facts on their own do not constitute the basis for any, do not form any basis, or do not form any conclusive evidence on their own. It is not a case that, in the present case, what we have found is that apart from the aforesaid suspicious activities of the appellants, there is no evidence which link the appellant with the incident. While the dead body was recovered, it is to be noted that the appellant had no role to play, in as much as the dead body was not recovered at the instance of the appellant. There is also no evidence to show that the appellant was seen last together along with the deceased, so as to implicate clearly the appellant. There is also no evidence that any weapon of the offense or crime had been recovered at the instance of the appellant. Therefore, apart from the suspicious activities of the appellant, we do not find any evidence which would implicate the appellant in the aforesaid commission of crime. Under the circumstances, we are of the view that the circumstances so relied upon by the learned trial court to convict the appellant are too tenuous to uphold the conviction, in a much as it would be merely based on suspicion rather than based on any established facts. We also have noted a very critical evidence which have come up in the form which is mentioned in the post-mortem report, which mentions that the deceased had burned, deep burn.
Page 75. Yes.
Page 75. In the evidence of page 75.
No, my lord, yes, I'm wrong.
What about in the post-mortem report? Page 20, page 28. The TW9 Dr. Tapan Das, who performed the post-mortem over the dead body of the post-mortem examination over the dead body of the deceased, had mentioned in his evidence that the deceased had deep burn injuries. Is it mentioned in the post-mortem report?
It was mentioned in the.
How? It is not there
It is there, my lord.
in the post-mortem report.
Yes, yes.
Date was instantaneous, resulting with shock. The injuries is anti-mortem. Cause were blunt force opinion. Injuries were homicidal nature. But there is nothing of mentioned deep. What is this deep burn injury? From where it has come?
Well, in the evidence, it is there, my lord.
In the evidence, but how can he give evidence based on what basis he is giving evidence? Blood codes. But there must be some reflection in the post-mortem report also. Post-mortem report. Healthy condition. Maggots present, genital, body, floated, washerman, ensign, chop, third.
It's not there, my lord.
It is not there. Huh? I don't know from why this doctor has given this. Huh?
The
Abdul- huh?
original postmortem report.
Decompose, healthy. More detailed injury of disease. That was instant reason for chop injury, anti-mortem, sharp weapon, called the blunt force.
This is a statement, my lord, because up to large intestine, my lord, I think it has been taken from the PM
I
report.
think then let's forget about it. There must be also. I hope this doctor was not consuming ganja also. I don't know what kind of. Huh? What kind of evidence they are giving without any reference? Deep. Huh? How can?
He's clearly saying this is a deep burn injuries.
They have copy pasted, see, now suddenly this comes. Well-built adult female blackened by whole body burned in linguistic attitude with solid face. Here in this.
Kerosene found, smell of kerosene found.
in
Yes.
What kind of is this? The doctor, he just signs.
Stained nasal discharge.
I don't know what kind of
That
word.
is a
Something
problem.
seriously wrong. I think better not to mention all this. Huh? Kerosene found. I think they must have brought from some
Somewhere they have bought the body and.
dead body. They just cut and paste. Kerosene found from how can you kerosene smell of kerosene? Anyway, forget about that. Huh? You said that this. Under circumstances of the view that except for strong suspicion of commission of the crime by the accused, unfortunately, there is dearth of legally sustainable evidence to sustain the conviction based on circumstantial evidence in MHS. It is now in MHS is well settled. It is held by the Honorable Supreme Court in quoted Sarat Bidhichand so. Huh? Sarat Bidhichand Sada versus State of Maharashtra, page 15. The conviction based on circumstantial must be if the conviction before a conviction can be sustained based on circumstances, the following must be fully established. Huh? We do not consider that the aforesaid circumstances, the aforesaid mere circumstance of his being absent and the absent is not sufficient to sustain the conviction in absence of any other material which would implicate the appellant. इसका पहले भी लिखो, हाँ, because we also have noted that उसके पहले ना, before that, we also noted that the appellant in his statement made under section 313 CRPC did not make any statement in his defense except for stating that he has been falsely implicated and he does not know why his son had made any statement against him. But on close perusal of the evidence of his son, we do not see that his son did not make any incriminating statement against his own father. In fact, he was declared hostile.
He also said he was not present
And
on the
who?
date of the occurrence,
Who?
the accused.
Yeah.
He also stated that
Hmm.
he was not present. I was not present in my house on the date of occurrence.
Therefore, in our view, further, it may be also noted that mere false statement made by a statement made by an accused during in the course of the trial, even if it turns out to be false, may not be sufficient to implicate him in absence of any evidence against him. Merely because, you see, the law is also subtle, no? If he is,
Substantive evidence.
no, in as much as such, in absence of substantive evidence against him. See, merely making a false statement cannot be a reason, cannot be a substitute, huh? And it also it cannot be a substitute for the evidence which is required for conviction. Mere false statement made by an accused under section recorded under section 313 cannot be a substitute for the substantive evidence required for conviction for commission of a crime. Under the circumstances, we allow this appeal. The impugn conviction order dated, judgment order dated 17/3/16 parts in so and so, huh? Page 43 is set aside. The appellant accordingly will be set at liberty forthwith. The bail bond, huh? No, but bail bond there is nothing. Huh?
He's outside.
He's outside, he's out on bail. He's out on bail.
No,
Huh?
Yes.
No, well,
I don't know, my lord, that I don't.
This is
know.
jail appeal.
No, he's
Okay.
serving. sentence.
He's serving, he's on forthwith if he's still detained, if he's still under detention, and if he's already on bail, the bail bonds, etc. shall stand, bail bonds shall stand, recalled. Okay. It has been, IA is there. I think he may be on bail also. Maybe that is why perhaps the learned a court also, after seeing that, maybe have enlarged on bail also. Because there is no evidence.
What is that?
Hmm?
This is on the circumstantial evidence. Careful.
Oh, because we did not see, because had it been recovered at an instant, that would have a very clinching, But his recovery was not his instance. Or any weapon of crime also, nothing was such. Okay. Any other matter, I think, second
There
half?
is no other matter.
No other matter. Okay. If there is anybody come, then you just let us know, then we'll come, otherwise.
2 cases in the first half enough, I think.
Okay. Okay, yes.